and welcome also to our audience guests from the law school, from around the country, and around the world. We open this meeting with gratitude to both panelists and audience guests for sharing and helping to fashion what we believe will be an absorbing and important conversation. I'm Scott Brewer, professor here at the law school. My co-host is Dan Kahan, visiting professor here and professor in law and psychology at Yale. And, most important, my co-clerk for 2 years, one of those years working as happy toilers for panelist Judge Harry T. Edwards. We've titled our panel, Evidence, Science, and Reason in an Era of Post-Truth Politics. An Oxford Online Dictionary has denominated the phrase post-truth as the word of the year for 2016. One may understand that this phrase is used for disturbingly appropriate reasons about the nature of politics in the US and other places around the world at this moment in history. Even so, one may also ask whether it's not overly nostalgic, whether it looks fondly on a pre-post-truth politics that was somehow firmly or significantly more firmly anchored in truth. Whether overly nostalgic or not, it is not difficult to discern what is of deep concern about the operation of a domain that is post-truth. In a post-truth domain, canons that call for careful weighing of evidence and the testing of judgments about what is true are either overtly rejected and disparaged, or silently disrespected and unheeded. Let's call canons that call for careful weighing of evidence and testing of judgments about what is true canons of evidentiary reliability. With our three panelists, we have convened world-class and nationally prominent wisdom on the question of how one might construct a system of legal proof in which scientific evidence is used in accord with canons of evidentiary reliability. In 1993, Professor Charles Fried, sitting in the center, argued before the US Supreme Court the landmark case of Daubert v. Merrill Dow Pharmaceuticals as counsel for Merrill Dow. That case set the foundation for what has evolved into the current legal framework for use of scientific and other kinds of expert testimony in the federal legal system. In 2009, Judge Edwards, sitting on the far left there, co-chaired the Committee on Identifying the Needs of the Forensic Science Community of the National Academy of Sciences. That committee issued a report entitled Strengthening Forensic Science in the United States, A Path Forward. The impetus for this committee's report had come in 2005, when the US Congress, at the urging of the Consortium of Forensic Science Organizations, passed legislation directing the Academy to create an independent committee to study the forensic science community. In 2016, Professor Eric Lander, sitting on the right, was co-chair of President Obama's Council of Advisors on Science and Technology, PCAST, an external scientific advisory group for the White House, on which Judge Edwards and Professor Fried were also both senior advisors. In 2016, PCAST issued its report to the President on forensic science in the criminal courts, ensuring scientific validity of feature comparison methods. Thus, all of our panelists have been deeply concerned with the question of how the truths that the best of science has to offer can inform and guide what is called forensic science in such a way that when judges and jurors rely, as they clearly do, on forensic science, they are actually relying on information that legitimately and accurately claims the mantle of scientific truth. That is, all have been centrally concerned that the forensic scientific evidence that enters the federal legal system meet the canons of evidentiary reliability, and in so doing be not post-truth, but truly scientific. In his brief for the Supreme Court in Daubert, for example, Professor Fried offered a sustained and clearly influential argument for the proposition that the legal evidentiary requirement that evidence have an adequate foundation must be understood to require that evidence proffered as scientific actually meet the demands of science. The NAS report produced by Judge Edwards' committee reached a sobering conclusion about the failure of most so-called forensic science to meet the requirements of evidentiary reliability. In the words of that report, and I quote, "With the exception of nuclear DNA analysis, no forensic method has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. The simple reality," the report goes on, "is that the interpretation of forensic evidence is not always based on scientific studies to determine its validity." 7 years after the NAS report, the PCAST report produced by Professor Landry's committee reached similar conclusions about a common type of forensic evidence used in criminal trials. It sternly concludes, well in accord with the NAS report, that, and I quote, "Reviews by competent bodies of the scientific underpinnings of forensic disciplines and the use in courtrooms of evidence based on those disciplines have revealed a dismaying frequency of instances of use of forensic evidence that do not pass an objective test of scientific validity." The response to both reports has been, or seems to me anyway, dispiriting. According to a statement that then Attorney General for President Obama, Loretta Lynch, released, I quote from her statement, "We remain confident that when used properly, forensic science evidence helps juries identify the guilty and clear the innocent, and the department believes that the current legal standards regarding the admissibility of forensic evidence are based on sound science and sound legal reasoning. While we appreciate," the statement goes on, "their contribution to the field of scientific inquiry, the department will not be adopting the recommendations related to the admissibility of forensic science evidence." In testimony at a 2009 congressional hearing on the NAS report, then Senator, current Attorney General Jeff Sessions asserted, and I quote from his testimony, "The commission report has some good recommendations. I don't accept the idea that they seem to suggest that fingerprints is not a proven technology. Maybe we can tighten that up and have some sort of better scientific basis for fingerprints and other analysis, but I don't think we should suggest that these proven scientific principles that we've been using for decades are somehow uncertain and leaving prosecutors to fend off challenges on the most basic issues in a trial." More recently, the Sessions Justice Department appointed Ted Hunt, a former prosecutor, as was Sessions, as senior forensic advisor overseeing a forensic science working group to create guidelines for forensic examiners to follow in court testimony. Hunt was a commissioner on the National Commission on Forensic Science. President Obama had established this commission in 2013 in lieu of the NAS report's recommendation that an independent government agency for forensic science be created, and Attorney General Lynch accepted several of this commission's recommendations. Ted Hunt was one of 2 commissioners to reject the recommendation that forensic experts and attorneys working on behalf of the Justice Department stop using the phrase, and I quote, "to a reasonable degree of scientific certainty." Earlier this year, pursuant to an executive order whose stated goals include, quote, "supporting law enforcement" and, quote, "restoring public safety," the Justice Department disbanded the National Commission on Forensic Science and created a task force on crime reduction and public safety. I conclude these opening remarks by returning to the concept of post-truth politics and its relations to the doctrines and institutions of evidence law. When political authorities, such as Congress and the executive branch, choose to reject procedures that are designed by experts in both law and science to assure that it is scientific truth that guides forensic fact-finding, they seem to engage in a non-scientific truth politics, whether or not this is post-truth, harking back to some supposed age of truth. All 3 of our panelists have been national leading figures in differing ways and from differing backgrounds in the effort to move forensic science away from non-truth to best practices scientific truth. We are grateful to them for sharing their current views about this effort in general at this moment in our country's political and legal history, perhaps by recounting their own experiences in their roles and the institutions they served. But before I turn the floor over to my esteemed colleague, Dan Kahan, we thought it useful to play just 4.5 minutes of a clip from a very recently aired TV show that makes clear both the human and societal costs of non-truth forensic science, or what we might call, in keeping with our theme, fake forensic science news.
Crime. You know, that thing that was almost solved by a flasher dog in the 1980s. But specifically, this story is about how we increasingly solve crimes using forensic evidence. It's that thing that is just a staple of TV crime shows.
Bullet from the torso on the left, bullet from the boat on the right.
2 hearts beat as 1. That matches up perfectly.
That's a match.
We got a match.
And they just found us a match.
Visible match.
We have a match.
Match.
Were you able to determine which monkey bit him?
The bite marks matched those of the monkey found at the scene.
Wow! That last one was presumably from one of the crossover episodes where the team from Law & Order worked a case with the cast of Monkey Law and Monkey Order. But on TV and in real life, forensic science plays an important role in criminal convictions. Prosecutors often complain about a so-called CSI effect, where jurors expect to see forensic evidence in every case. The problem is, not all forensic science is as reliable as we've become accustomed to believe. A report in 2009 by the National Academy of Sciences found that many forensic sciences do not meet the fundamental requirements of science. And a report last year by a Presidential Science Council agreed, saying that expert witnesses have often overstated the value of their evidence, going far beyond what the relevant science can justify. And that's the thing here. It's not that all forensic science is bad, because it's not, but too often its reliability is dangerously overstated. And one sign of that is that forensic experts in court are often nudged to use one very convincing phrase.
To a reasonable degree of scientific certainty.
To a reasonable degree of scientific certainty.
To a reasonable degree of scientific certainty.
Within a reasonable scientific certainty.
To a reasonable degree of scientific certainty.
Are you able to say that within a reasonable degree of scientific certainty?
Yes.
And here's the thing, that phrase does have a persuasive ring to it. Unfortunately, as that Presidential Council pointed out, it has no generally accepted meaning in science. It's one of those terms like basic or trill that has no commonly understood definition. Am I trill? Is that good or bad? I mean, I do feel trill, so I'm guessing it's awful. And when bad science is confidently presented, terrible convictions can happen. In fact, among the hundreds of people who've been exonerated by DNA testing since 1989, in nearly half of their cases, there was some misapplication of forensic science. And there are people behind those numbers. Take Sante Tribble, who was convicted of murder and served 26 years, in large part thanks to an FBI analyst who testified that his hair matched hairs found at the scene. And as he will tell you, the evidence was presented as being rock solid.
They said it matched my hair and all microscopical characteristics. And that's the way they presented it to the jury, and the jury took it for granted that that was my hair.
But you know, I can see why they did, because who other than an FBI expert would possibly know that much about hair? Except, of course, for whoever starred Amanda Seyfried at the 2009 Oscars. Breathtaking waves without losing any of their body or bounce. Stunning. 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 The jurors in Tribble's case were actually told there was one chance in 10 million that it could be someone else's hair. And guess what? He was exonerated. Because once DNA analysis became available, his lawyer tested the 13 hairs from the case, and not only were none of them his, some of what they found was incredible.
9 of the hairs had come from the same source, a couple had come from different sources, and 1 was a dog.
2 different FBI agents who had looked at that and analyzed it didn't recognize that it was dog hair?
It was a canine. It was a domestic dog, yes.
My personal conclusion was the dog committed the crime.
Okay, so first, it is amazing that he is able to laugh at that. But
How's this? It's better? No, I couldn't add anything that would set up the discussion better than what Scott has already said. So I think we'll just move directly to the speakers on our panel, and they can go in the order in which they're sitting. So Judge Edwards, we'll hear from you first.
Okay. Let me try and give you a sense of what I've seen since I was involved with this enterprise beginning in 2006. As you've heard, I co-chaired the National Academy of Sciences committee that issued the report in 2009. I'm not sure why I was selected to participate. There were a lot of really good scientists. There were some lawyers, some folks in public policy, but I was a co-chair with a scientist from Brown. And I really was not sure what I was getting into, and I certainly had no understanding of the frailties of forensic science. But they got my attention when we examined, we spent 2.5 years examining people and going through all of the research that was available. And I remember two things that got my attention. One was when an expert in microscopic hair examination, someone who had been using this technique for years, testified, and I said, I began to realize this was frail. And I said, let me ask you something. If your daughter was on trial and the only evidence that they had to convict her for a serious felony was testimony from an alleged expert with regard to this microscopic hair examination, would you be nervous? And he said, yes, I would. I said, well, that's interesting. And then the guy, an expert in fingerprints, which is supposedly a gold label discipline next to DNA, testified, and I said to him, let me ask you something. If you have a partial print that you've lifted, what is the science that you have that allows you to testify that that partial print matches the human source? To which he said, we haven't done that research yet, which was stunning. They had my attention from that moment forward because I realized how serious the problem was. When we finished, it wasn't just a matter of exposing some of these disciplines, and we're talking about a number of different disciplines. For those of you you're not aware of forensic science, it could be fingerprints, DNA, firearms, shoe marks, hair, bullet lead, arson, bite marks. Those are the kinds of things that we're talking about. And we found lots of problems, as did Dr. Lander's PCAST report. But in addition, we found a community, the forensic science community, in disarray. There was an absence of solid scientific research with respect to validity and reliability in these disciplines, quantifiable measures of uncertainty. There was no serious research on human observer bias in a number of these disciplines. The forensic laboratories across the country in a number of instances were in terrible trouble, and after we issued our report, a number of them had to close down because they were exposed. What we had to say put people on notice, and several had to close down because of their practices. There were not mandatory certification or accreditation procedures across the country. Experts were testifying in court not using standard terminology, and there was no effective oversight. We called for the creation of an independent federal agency that would oversee scientific research and create a culture that was strongly rooted in science. And one of our most important recommendations was that DOJ, the Department of Justice, should not be that agency. They should not be in charge of the enterprise. They had a vested interest in prosecuting. It's inconsistent with a culture of science. And it was one of the most important discussions of the committee. We were all, to a person, unanimous in the view that DOJ had to be kept out of it. And boy, were we prescient. Our worst fears have been realized. Our worst fears are we got no serious help from DOJ once the report issued. And that goes through both administrations, through all the administrations that have been involved. And the only time DOJ has acted in a way that has been useful is when they've been under pressure. For example, when they were exposed on microscopic hair examination, And there was enough evidence, the Washington Post was reporting enough potential cases so that they had to fess up and they had to compromise, and they were willing to open thousands of cases and revisit the files because a number of their experts had testified erroneously with respect to matches from microscopic hair. Other than that, we were not getting help from DOJ. And I had former law clerks who were working in DOJ, and I was appalled we could get no support from the department to try and advance reform movements. The other part of our worst fears realized is DOJ is now the self-anointed leader of the forensic science reform movement, which is a disaster. And I say self-anointed, they simply stepped in to fill the gap because it hasn't been filled elsewhere. And it's shrewd on their part because they want to control what is and is not done, mostly what is not done. And they are in control right now, which is really unfortunate. Now, there was some momentum, just so you get the full picture, after the report issued. It has become cited throughout the world because it had such a large impact on what people assumed was good science. And we were saying quite the contrary. And it has been cited, reported, discussed, conferences, articles, etc., across the world. It was that important. The settlement of the hair cases, press reports, and the National Institute of Justice has begun to sponsor some research to try and improve some of the disciplines. And in 2013, as Scott mentioned, DOJ, and in my view, under pressure, because a lot of us, including the press, had been pressing for some movement, they co-sponsored with the National Institute for Science and Technology the creation of the National Commission on Forensic Science. And that commission were going to be included a group of scientists, practitioners in the field, policymakers who would come together twice a year to look at the problems in the forensic science community and to recommend reforms. Now here's the problem. DOJ held on to it. Not NIST, DOJ. So any recommendations coming out of this group went to DOJ, and DOJ decided whether or not the recommendations would be implemented. Most of the recommendations have not been implemented. They only met twice a year. There was no real leadership, and at one point, one of my colleagues, Judge Jed Rakoff, district court judge in New York, resigned from the commission because DOJ was going to limit the scope of their work, and he wrote an article, an op-ed piece in the press, and they backed down. He forced DOJ to open it up again, but they had no enforcement. The recommendations were not being accepted by DOJ, but there was a little bit of progress because at least until they were shut down, they started to come together around some recommendations that would have advanced the forensic science project. Then we had the 2016 PCAST report, and Dr. Lander will explain that. And this was a really strong report, saying again what the National Academy of Sciences had said in 2009, essentially saying with respect to these pattern matching disciplines, there are serious problems. This is not science. You have people testifying about things on the assumption that it's science, and there was no scientific basis for what they were saying. And then you have the current Department of Justice. Now, I should emphasize what Scott said. The PCAST report came out, DOJ, then Attorney General Lynch, it didn't matter because Sessions had said the same thing, gave it the back of the hand, said we're not interested. They tried to block the issuance of the White House report, DOJ did. I know about the internal battle. I'm perfectly comfortable to mention it now. Eric won't have to. These were world-class scientists who had studied all of these disciplines, had come to some very serious conclusions about the frailties of these disciplines, and DOJ pressed the White House not to let this report come out. It finally did come out. DOJ said we're not interested, and when the new administration came in, DOJ said we're still not interested, and we're not going to apply any of the recommendations here. The current DOJ, and I had an opportunity to hear the new leader within the Department of Justice, Ted Hunt. He spoke to the National Academy of Sciences a week or two ago at a meeting that I was at. This is a person who had been on the National Commission of Forensic Science, had voted against a number of proposals that would have helped to reform the forensic science community. He blasted the PCAST report and said they didn't understand what they were talking about with respect to science. It was really one of the, I really wish I could have videotaped the exchange when he blasted PCAST, and I'm sitting in a room with world-class scientists, the National Academy of Sciences, and he did his critique on scientific research, and one of my colleagues couldn't stand it any longer, and she said, "What are you talking about?" She said, "I teach scientific methodology every Friday at 1, and you haven't the faintest idea what you're talking about." And that's it was exactly accurate. They had no sense of scientific methodology, and he was blasting the PCAST report. He made a comment that was one of the most astonishing things I've ever heard. He said, and incidentally, the jury is still out on bite marks. The jury is not still out on bite marks, trust me. There is no science supporting bite marks. And yet, it is still a discipline that we use in the United States, and it's still being accepted by the courts. And this new person who's heading the forensic science wing at DOJ had the chutzpah to say to us, the jury's still out. And I said, well, if you're really serious about advancing reform, wouldn't the first thing you want to say to the world is bite marks is gone as far as we're concerned? And that's when he said the jury was still out. He had no interest in an independent group overseeing the reform effort, and he may kill the NIST, the National Institute of Science and Technology effort. Now, let me just say briefly, I don't want to take up all the time, we can answer questions. The National Institute of Science and Technologies, National Commission on Forensic Science is dead now because justice has killed it. So an enterprise that might have produced recommendations that could have been helpful is no longer existent. There's this guy in justice, Ted Hunt, respectfully, who's now called head of it all, and he has his little working group, and no one knows what they're doing, and they refuse to have an independent science group oversee it. All right. NIST still exists, and they oversee scientific area committees. And what they are trying to do is establish standards in the disciplines for each of these groups. But I want you to understand, and then I'll stop for now, wait for questions. I want you to understand, while this is a noble enterprise in some respects, it's not going to get us where we need to go. The NIST enterprise with these area committees is pretty much dominated by forensic practitioners. Forensic practitioners are the people who got us in trouble in the first place. They don't know what they don't know. That's the problem. And I mean this very seriously. That was one of the first things that hit me when I got into this. The people who are doing this do not understand what we mean when you say to them, what you're doing has no scientific foundation. They don't understand it because they were brought up in a different world, and they don't understand science. The disciplines that they are now trying to set standards for, many of them have not been validated and have not been shown to be reliable. So how do you set standards for a discipline that is not shown to be valid and not shown to be reliable? That's one of the frailties of this whole NIST project. These practitioners do not want to know sources of variability. They don't want to try and understand error rates. They don't want to believe that uncertainty exists. They object to blind studies that would help to confirm the reliability of their work. They're persuaded by very small sample sizes, and they fight the real scientists with whom they're working on these area committees. And they dominate the committees by 70% to 30%. And the real scientists on these committees with whom I've been in contact say it's a nightmare trying to struggle with them because they don't understand the issues. The last thing that I'll say is, because I know this will come up, the exaggerated testimony in court is horrible. We have people testifying 0 error rate, vanishingly small, essentially 0, and we had appellate opinions in the federal courts adopting zero error rates as if it was a viable notion. There is no such notion in science. And Fingerprints and other practitioners came in and said, Your Honors, it's a zero error rate here, so we know what we're saying is correct. There is no such notion, but the courts were repeating it. The other thing is the federal rules are no help, and I'll leave that to discussion. Rule 702, which was based on Daubert, which purports to talk about scientific validity. Daubert has been, respectfully, Charles, a failure in the criminal arena side. It has done decent work on civil cases. In criminal litigation, the notion of scientific validity that is very much a part of Daubert has not worked. It has failed. And it has failed because of long-lasting system, judges who are wedded to precedent, who believe that because we said it before, it must be right, and because these practitioners have been around for a long time, it must be right. In other words, history is the proof, and precedent controls. They will not even allow, in the criminal cases, unlike the civil cases, a lot of judges will not allow Daubert hearings, which would be the test of validity and reliability of these disciplines, and our courts are not allowing the test. And they believe these experts when they come in. And when the experts come in, even when they have some science, and Eric, you can explain this, on bullet lead, these were chemists testifying about chemistry. And they were right about what they had to say about the trace elements of chemistry. The problem was they were trying to extract from that factual inferences with respect to which they had no basis to make any claims. They were trying to assume that because they understood the chemistry of the bullets on the one hand and the bullets in the hands of the defendant, that they could somehow conclude there was a match. But the thing they did not know how to do was a statistical analysis to look at variability and area rates. They don't know anything about it. And the courts didn't know they didn't know anything about it. And it wasn't until the National Academy of Sciences finally reviewed that area in 2005 and said, this is not science here. And the FBI finally conceded that bullet lead should not be a discipline with respect to which we give any respect. There's so much more to say. I'm going to stop now.
We'll get to it together.
Yeah, we're going to get to it. Go ahead, Charles.
Charles, actually, before you start, can somebody see if I can show slides after Charles? Is that it's working? Because I might show a few pictures. Charles, sorry to interrupt.
If anybody was in Sanders Theater yesterday, Justice Breyer gave a quotation from Brandeis, which should be the motto for this. Men feared witches and burnt women. He's gone. But that's what happened. The juries feared the defendants and incarcerated or executed human beings. So that was Breyer, and it's still true. It's still true. My role in this, which actually I'm quite pleased about, was easy, because where it came up was in civil trials, and it was tort trials mainly, having to do with issues such as whether a particular chemical, was usually a therapeutic chemical, had the capacity to cause a particular untoward event. And fortunately, this is something which was studied regularly before these substances could be put on the market. The Food and Drug Administration usually required enormously rigorous randomized double-blind trials. So we were in an area where good practices existed. They just didn't exist so clearly in the actual civil trials where somebody was trying to blame a substance for a particular untoward result. But in general, the government, Food and Drug Administration, at least for the moment, operated in a perfectly correct scientific manner, exemplary. Indeed, perhaps demanding almost too much evidence, but the gold standard, randomized, double-blind clinical trials. In the civil justice area, this had to do, the particular case I was involved with, had to do with a substance called bendectin, which in fact was an antihistamine that was and still is the principal ingredient in NyQuil, which you can buy over the counter. And it was used to treat morning sickness in pregnancy. Millions and millions of women all over the world used this drug. And since some 3% of all births have birth defects, 3% of these millions and millions of births did lead to birth defects, and plaintiffs' lawyers saw a gold mine here. And so they claimed that, wherever this woman had taken bendectin, and there was a birth defect, that proved to scientific certainty that was a causative element. Well, the trouble was, though bendectin had been studied and studied and studied and had been passed by Food and Drug Administrations in Great Britain, in Canada, in New Zealand, in Australia, all over the place, passed these very rigorous tests, plaintiffs' lawyers were nonetheless seeking to come into court to say, well, it's possible that it did it, and my expert has examined the bumps and so on, and it feels like this was caused by bendectin. That kind of thing. We'll talk about post-truth truth. That was what was involved. The dispute in the Supreme Court was between two wings. One wing was, and it is embarrassing if I give you the names of some of the people who were on that wing. Their secret is safe with me, but if you look in the public record, you can find it. Well, they said this is all so uncertain that what we should do is, if somebody has qualifications to testify, usually a PhD, but not necessarily even a PhD, if the witness is qualified, then the witness should be allowed to testify and leave it to the jury. A scary proposition because it's very difficult to understand, and leave it to the jury means that most defendants would say, oh God, we throw in the towel, we'll settle, how much do you want, before you get to the jury. That's one wing, qualifications only. The other wing was equally extreme. It was, they were the traditionalists, and the traditionalists said no substance, indeed no method which has not been already accepted can be proposed in evidence. And that too was too extreme. And what we argued is, well, the actual claims do not have to be scientifically generally accepted. What has to be generally accepted are the methods by which the witness has arrived at the conclusions to which he or she is going to testify. If the methods are the methods of science, then the person may testify as to the conclusions arrived at by those methods. However, those methods include where something is generally tested and of general scientific interest, publication in peer-reviewed journals, presentation at scientific conferences, and of course, some of this, what we call junk science, was of course never presented at any conference because people would have sunk into the floor in shame had they done it. Never published in a peer-reviewed journals, although I would like to say that peer-reviewed journals are now coming into existence, which are sponsored by the interested parties, and so then you'll get the peer review, and that's very post-truth truth, very definitely. That's beginning to happen. And don't get me onto the subject of scientific journals, because there are many of them. Some of you who are in the business may get calls for papers from them. And if you deliver the paper to them, it'll only cost you about $10,000. Yes. And which, if you have a sponsor and a case to make, is well worth it. And then it will have been peer review. But that is what we got the Supreme Court to say. That it's not the conclusions. You can testify as to the conclusions. It is the methods by which you arrived at them. Now, let me just say that that was the easy part. And our domain was an easy domain because it was the domain of causation in areas where there were really quite regular methods for testing this and institutions that did it. The trouble is that in the work which Harry's talking about, we're dealing with fingerprints. We're dealing with field sobriety tests. How many of you have heard of the I can't pronounce it, gaze, horizontal nystagmus gaze test? Nystagmus, thank you. Which has to do with whether your eyes waver when the arresting officer waves a pencil in front of you. And if so, you maybe were drunk. And of course, if there's been a death, you may be guilty of vehicular homicide. But it's worse than that, as Harry has been talking about. Eyewitness testimony. Yep. That is supposed to be the gold standard. That is what people have been convicted on since the Garden of Eden, since Cain killed Abel. And that, it turns out, has also not been scientifically validated. Indeed, such science as there is on eyewitness testimony is very discouraging, to say the least. And in the court on which I sat, we solved that problem by at least requiring that the judge instruct the jury about the uncertainties that attach to eyewitness testimony. But if eyewitness testimony is vulnerable in that way, well, God help us when we get to fingerprints, bullet lead, bite marks, hair samples. So there is a real problem here, and I have no sympathy with the current Department of Justice, but I must say I do have sympathy with those who are in the business of calming the fears which men and women have of witches, which lead them to therefore burn women.
Well done. This is wonderful because what Professor Fried has done with Rule 704 to establish, I'll put that there, to establish the idea that expert testimony has to be based on reliable principles and methods was an incredibly important first step. What Judge Edwards has done, we'll somehow make that work. Yes, good.
702.
Yes, what Judge Edwards has done with the National Academy Committee report was put the first big stamp of science on the proposition that there are serious problems with forensic science evidence. I could be discouraged, but I'm not. I take a very long view of the law. We get a lot of things wrong for a long time. We get them wrong sometimes for a century. You got to beat your head very hard against the wall. And so I co-chaired the President's Council of Advisors on Science and Technology and took up my post beating our head against the wall. And eventually, the wall will crack. It will cost a few heads along the way. But I'm going to describe this because what Judge Edwards did was write a spectacular report that pointed out all the scientific problems. And the Department of Justice dismissed it because they said it was about how to make forensic science better. That's all great. You should consider that. But it doesn't really speak to the admissibility of evidence. You see, if it wasn't about admissibility, they didn't really care. Because if you came into court and you could talk to a jury, well, you didn't have to make it better. So PCAST took the next step. We wrote a report that was about Rule 702. We really didn't care about anything else. We weren't writing about how to improve forensic evidence in general. We took on the question of this Rule 702 that Charles breathed meaning into. Exactly, thank you very much. We will get there. This is the text here. What we did, and then I'm going to tell something that Judge Edwards does not know that he will find very interesting because it'll explain why I'm showing a few slides. I'll explain it in just a second. PCAST is this group. We didn't specialize in forensic science. We did 39 reports for the president on cybersecurity, on spectrum policy, antibiotics, national security issues. We took on many topics, and in each case, we got us a group of members of PCAST plus a set of advisors. But this was one of our deepest reports. We wrote 173 pages, almost 400 footnotes, reviewed 2,000 papers. I personally looked at 2,000 papers. And we made an analysis of 7 fields. But it's all focused around the question of, were these fields foundationally valid? Were they based on reliable principles and methods? And we did not pull our punches about the fact that that was about admissibility. We made a set of recommendations to the National Institute of Standards and Technology, the Office of Science and Technology Policy, and the FBI and the Department of Justice, and also to the Judicial Conference of the United States, which has a committee on the federal rules of evidence. We made a specific recommendation to this Standing Committee on the Federal Rules of Evidence that they revise the advisory note around Rule 702, essentially that 702 needed fixing. This morning, they met. I have come from that meeting this morning where I spent 4.5 hours with said committee that convened in response to the PCAST report. And these are the slides I showed them. There were only 10, so I'm going to show you because the alignment of stars is just wonderful that this happened this morning. And Ted Hunt was there. And we had a grand old time.
Sure you did.
I'll tell you. So I'm still full of vim and vigor about this thing here. So briefly, a forensic feature comparison method is basically some scientific method to take two samples, you look at them, and you compare features, some class of features. You pick a class of features, that defines the method. You say, are the samples indistinguishable? If so, how often do samples from different sources look indistinguishable? You can't actually answer it unless you have both parts. It's not enough to say, I couldn't tell the difference between his hair and his hair unless I know whether the way I'm looking at it, that's a particularly meaningful statement. I actually need to have data to know how often that occurs. There's a lab component and a quantitative component. So what does it mean for a method to be reliable? Well, first let's ask, why do they have to be reliable? Well, there are 4 reasons. The first 3. Forensic feature comparison evidence is seen to be highly probative and claimed to be highly probative. If you do surveys of mock jurors, they think it's about 1,000,000 to 1 chance, if you say nothing, that things would match. So that's the assumption that you're going in with, and therefore there's tremendous potential for prejudice. There's this Rule 403 about prejudicial impact of evidence. Also, it is impossible to for a lay juror to independently interpret such evidence. It's one thing if you say, the guy had red hair and was tall. People can interpret that. If you say there were these many whorls and that many loops in the fingerprint that were aligned that way, you cannot interpret whether that's meaningful, how rare that is. And so, again, tremendous opportunity for prejudice. Finally, this is not a theoretical worry. There have been hundreds of wrongful convictions based on incompetent use of this evidence. Finally, there's another reason why it must be reliable, and that's Charles. Reliability is a requirement. It's not a nice to have, it's a must have. Rule 702 says that expert testimony is admissible only if the testimony is based on reliable principles and methods, and that the expert has reliably applied those principles and methods. Daubert makes clear that when they mean reliability, it says in the famous footnote 9 in that case, it will be based on scientific validity. So that established, because of what Charles did, the court is a gatekeeper. It's not enough to say the evidence is relevant and therefore should come in and the jury should consider it, and you can always dispute it on cross-examination. There's a gatekeeping function.
Now add one thing so they understand. 702 starting out says among the things you look at to determine whether someone is an expert is his or her experience, which is a nightmare.
Yeah. But at the moment, I'm just reading the rule.
All right. That's part of the rule.
Yes, I understand, but the rule still requires that the method be shown to be reliable, and I'm going to hang on that.
And that the testimony be scientific knowledge.
Yes.
We're on the same
We're all,
page.
by the way, there's not going to be an opposing view on the panel. You might have figured that out by now. So why is it that this happens? Well, because most of these methods weren't developed to be science. They were developed to be rough heuristics for an investigation. And the truth is, under the law, you can use a Ouija board to form a hypothesis about who done it. There's nothing wrong with that. You got to prove it when you get to court. And that's true in science. Your inspiration for a hypothesis may come anywhere. The bar comes when you must prove truth. So the problem is that wasn't how this was established, and the courts have accepted this kind of evidence despite the lack of any empirical testing. So I amused the panel this morning by noting there were 3 stages of evidence. There's the stage of data-free claims, the stage of shooting fish in a barrel tests, and then the stage of empirical accuracy under conditions reasonably resembling the intended use. Here's my little chart. Fingerprints. 1984, the Department of Justice, in an official document of the department, which it disavowed last year, said, it did disavow it last year for the first time, that fingerprints were infallible, papally infallible. In 2009, a former head of the FBI crime lab testified in a case, the error rate was less than 1 in 11 million. Why? Because the FBI had done 11 million fingerprint cases and he was not aware of an error.
This is true.
This is true. It's cited in the PCAST report. Since the time of Judge Edwards' 2009 report, the FBI, God bless him, did a real empirical test of fingerprints. And we now have a measurement of an error rate. It's 1 in 600 is their best guess. Could be with error bars as high as 1 in 300. That's great. We now actually know it ain't perfect. It's not terrible, and you can tell that to a jury. But by the way, the claims were off by 17,000-fold before that point with this 1 to 1 million. Firearms. They did a whole bunch of fish in a barrel tests. They gave you a bag of bullets. They gave you another bag of bullets. They said, every bullet in here has a match in here. Figure out who matches. They make very few mistakes when you know that the right answer is there on the multiple choice test. If the multiple choice test includes none of the above, you might not do as well. You know that from tests. They did multiple choices without a not one of the above, and they found an error rate of 1 in 5,000. Then in 2014, the Department of Defense commissioned a study, and they found, well, 1 in 50, kind of like 1 in 5,000, just 100-fold less. Hair analysis, they did an amazing study in 1974, which the Justice Department cited last year as the foundational proof of the validity of hair analysis, in which they found the error rate was less than 1 in 40,000. That study involved giving people hairs and asking if they thought they matched, and by the way, telling the examiners, each hair you're considering comes from a different person. As a matter of fact, it's shocking they made any errors at all. When the FBI actually used DNA analysis on hairs that had been said by examiners to match, they found 1 time in 9 they got it wrong. And then bite marks, the literature that introduced the field said 1 in 6 trillion was the error rate. When you give them 4 choices of people, they still get it wrong 1 time in 6. In that closed set, a remarkable off by 1 in a trillion fold. And footwear matches is declared in the seminal textbook in the field to have an error rate about 1 in 683 billion. I can't tell you how far off that is because there has never, ever been an empirical test of footwear because they know they can calculate it must be that accurate. So our radical position, and I say radical because Mr. Hunt this morning described PCAST's position as radical, was that a forensic feature comparison method can be considered reliable only if its accuracy has been empirically tested under conditions appropriate to its intended use and found to have accuracy appropriate to the intended use. That's our radical position, which I think is sort of about the foundation of the scientific revolution, that empirical evidence is necessary. This would have been controversial in ancient Greece and other places, but in the last 400 years, this hasn't been so controversial. But in the forensic community, they doubt it. They argue other things can substitute for it. It's enough if the method is based on science, like based on a true story. The examiners, we haven't got reliability data, but they have good professional practices, training, certification, accreditation programs, professional organizations, best practices manuals, extensive experience using it, and published papers in peer-reviewed journals. And PCAST noted in passing that the same is true about psychics. If you go online, all of those indicia apply to the field of psychics. There are peer-reviewed journals for psychics, accreditation standards, etc. There's even a subdiscipline of forensic psychics, by the way. And so we said, those are all good. I don't want you to not have those things, but they can never establish reliability. So it's sort of flamingly obvious, but some people disagree. And of 20 speakers this morning, only 3 quibbled with the need for empiricism. They all were employed by the Department of Justice. There were Ted Hunt and 2 colleagues. I asked this question, yes, no, and I would say it broke down 17-3 on is empirical evidence actually necessary. And 17 people are post the scientific revolution, and 3 are, well, the jury is out, maybe, in the scientific revolution. In any case, I'll just add that the Department of Justice, as you might imagine, hated this report. They hated it. We did because we're very good group. We work with all the agencies within the administration. We're an inside-outside group. We reported to the president, and this was done at the request of the president. We then took it to the Department of Justice, as we do with all agencies, and let them know what we were thinking, and they had a fit. They had a fit because they said, "Do you realize this could jeopardize existing cases and past convictions?" And they said, "Could you grant us grace, like 3 or 4 years to fix all this before we have to live by these rules?" We talked and we concluded that as scientists, it was not within our purview to grant grace, that others might be able to do that. All we could do was speak the fact. And so we did, and they hated it, and they attempted very hard to kill the report. We did battle for about 4 months. The Justice Department sent over 300 comments, specific comments, and we dutifully answered every one and made small changes in response to them. And at the end, they still opposed the release of the report. And I will merely note that in the first inaugural, President Obama said, "We will restore science to its rightful place." The White House was faced with a disagreement between its science advisors as to whether a report should be released in the Department of Justice. The White House called the Department of Justice and said, "You're going to have to wrap your head around the idea this report's coming out." And it came out. One of our recommendations, as I said, was Federal Judicial Conference should take on this question of does 702 need to change either to the rule or to the advisory note. There was a robust discussion. There was no agreement as to whether the rule itself should be changed and how. There was a broad range of ideas about that, or whether the advisory note should be changed. We'd recommend you just change the advisory note. We were told if you don't change the rule, you can't change the advisory note. So I suggested put a comma in somewhere and change the advisory note. And they agreed that would trigger it. That would be fine. And we'll see where it goes. But it's a wonderful thing you've organized a panel on this topic, because with this thing this morning that I've just come from, it's a live issue. And science isn't rolling over yet. And I'm not holding my breath that anything's going to happen yet. But in the end, science does win out, and we're just going to have to be very, very stubborn.
In the long run, we'll all be dead.
But the next generations will be here. That was true for so many decisions in the law that have come along a century too late for many people, but they came along, and we have to hold the hope that we get these things right. That's why we keep beating our head against these things.
You should all be wondering why the courts haven't been able to step in and turn us in the right direction, since we're about justice, supposedly. And the frailties in the system really are pretty glaring. And I'm a judge, and so I worry about this a lot, and I've talked with my colleagues. And there are lots of reasons for it, and I don't want to make excuses. I just want you to understand what I think some of them are. First of all, the people who are testifying, as I've mentioned to you, the people who are testifying before us often don't know what they don't know. So we're starting with people who are not strong and bringing us what we need to work with. We often have defense counsel who is not up to the task. We have precedent, and judges are I'm not talking about politically, but they're conservative, and they don't want to move away from precedent unless there's some compelling reason. And there are a lot of cases out there saying that these disciplines are acceptable. And what the judges have done is to accept that precedent and not even allow Daubert hearings in the criminal arena, which is really very sad. The other thing that occurs to me is, and I'm curious to hear what my co-panelists have to say, one of the problems is, this is one of the problems with 702 and Daubert, we don't know how to quantify variability because there haven't been studies. Like fingerprints, they've finally done some work. In most of these areas, they have not. They have not quantified, done studies to quantify the variability, the error rates, et cetera. And the judges get this. So when the judges are told, and there's some judges who are willing to listen carefully, are told you should at least limit the testimony of the expert so they don't overstate and say match. The problem is, I think, if I could get my colleagues to do a survey, we don't know what that means. What do you tell the expert they can say and not say? And here's the problem you have. If you say to the expert, don't overstate, don't claim match, claim something less, the prosecutor is up in arms because it's proof beyond a reasonable doubt. And if you show any uncertainty coming out of the mouth of your expert, you may not meet that standard. So you have no support coming from the prosecution. And we don't yet know how to answer the question. What do we tell the experts are going to be the limits of your testimony? And we don't have any good case law helping us. Supreme Court's given us nothing. In the Melendez case was the best hope we had a number of years ago in 2009. They cited our report and said it was terrific, we need reform, and then nothing. And there's been no other case, and that's where I think we're stuck. The judges are not moving because I think they don't know how to limit the testimony of the experts in a way that would be effective and achieve what we're talking about.
Let me ask a question, because not being a criminal lawyer, I find this puzzling. I am a constitutional lawyer, and in my copy of the Constitution, there are two clauses, but essentially, it's been understood you've got to prove guilt beyond a reasonable doubt.
You don't have to sell me.
And you have, and there's the confrontation clause, much misused by Justice Scalia, but here it could really do a job. All the judges would have to do, but you're telling me they don't do it, and they're not doing their job, they're acting unconstitutionally. You get one of these phony experts, and they are phony. You know, some of them are, in the area, in the civil trial, they're not only phony, but they're crooks. I mean, they are what are known as paid liars. But that's a different thing. In the criminal area, in the prosecutor, they are professional liars, but they may not be paid. Nevertheless, why are the defense lawyers not allowed to poke these holes under the confrontation clause and under cross-examination? It would fall apart in cross-examination. And particularly if you had a contrary expert who did this. Why doesn't that happen? That would create reasonable doubt in an unreasonable number of cases. Why doesn't that happen?
Well,
you tell me, Judge.
I've never understood the bite mark example. I can't, and I say this with great sadness, because for me it's not funny.
But tell me what happens in the scenario.
They have tried in the bite mark area. The judges let it in. They've tried to do the cross-examination. It comes in. The judges let it in. If you can get someone who's been identified as a quote-unquote expert, you've got the jury.
But
it oversells.
But what if you get an expert on the other side?
And here's the problem. You don't have scientists, serious scientists like Eric, who have any interest in doing serious work in forensic.
You've got a day job.
That's a long time.
A couple of things to say here. It's an unusual kind of science when the scientists work for one side. In the case of criminal law, the forensic scientists work almost exclusively for the proposition. In civil law, this works because both sides get their experts.
Exactly.
And there is a community of experts prepared to serve both sides. A perfectly interesting question is, why are there not independent forensic laboratories that are established, which have to work for neither side? Data is sent, they do an evaluation, they send back a report. That would be an interesting possibility.
Don't they, the Innocence Project, couldn't they get into this business?
They have been in it.
Well, they can, but the Innocence Project, on whose board by disclosure I serve, is somewhat understaffed with its philanthropic support for the how many million criminal cases in the United States? I don't think they could do it. I think it's a national responsibility. Why are we putting the evaluation of truth in the hands of somebody who works for one of the interested parties? There's no particular reason for that. You could keep investigation in the hands of the police. They can have their investigative labs. But the evidence that is brought forward in court could have gone forward to an independent laboratory established by the Commonwealth of Massachusetts, and maybe we should.
This is one of the reasons we felt so strongly that you had to have an independent group overseeing this area. You have to.
With regard
because then the research would be done. and you could quantify the
Exactly.
But couldn't one...
I think members of the audience
We're going to get to
might
my
have
answer.
hypotheses, though, about some of these questions. That
I'm going to answer his very last question very quickly, his first question very quickly, which is, what do you do when you don't really know what your accuracy is? You don't have a method. End of story, which means it's not admissible. You cannot, if you do not know, I have a scientific method that measured something, I have no clue how accurate it is, it's not a method. It doesn't come in. It doesn't go to weight. It goes to admissibility.